in child protective services, and they won't give them back to their loving families because they're making money.
This is a legal system that you're going into. And if you don't know the rules, you will be chewed up and spit out.
If I could say anything to a mother who just got their children detained, you're in a crisis. Yeah. Life feels like it's over. The most important thing is regaining custody of your children.
The child welfare system at its core is designed to protect children who need protection. Okay, and that's key, is who need protection.
So social workers, out of fear, will remove more children rather than only remove those children that truly need to be removed.
It's okay. It's okay.
This isn't someone stole your car. Someone broke into your house. This someone took your child, your flesh and blood.
It doesn't say on this order that it was not proven. It says untrue. I immediately knew that, okay, well, this ain't over.
Were there signs there? Were there no signs? Did I miss them? Did I catch them? At this point, I honestly don't know.
Families only get a finite amount of time to reunify.
I came into this field to help families, not destroy them.
The difference between the criminal system and the child welfare system is substantial. You have more rights as a criminal than you do as a parent.
Good afternoon, everyone. My name is Georgette Truan. I am the host for Real Talk, CPS Real Talk with Ms. G, and I also work for Attorney Vincent Davis. Hi, Mr. Davis.
Hello, how are you?
I'm good, thank you. Hi, Sabrina.
Hi, how are you?
I'm good, honey. So Sabrina is with us today. She also hosts a show. Go ahead and say the name of your show, Sabrina, and when it's aired.
It's Fight CPS with Sabrina, and it's Fridays at 6 o'clock.
Okay. Thank you, Sabrina. So, Mr. Davis.
Yes.
So, I know that I brought this up to your attention before for like 18 hours. And I'm gonna, if you don't mind, sir, I'm gonna let everybody know that you agreed to give everyone a 50% off on their retainers. You're silent.
No, that's true. It's true.
And the reason I'm doing this, guys, is because it's a lot of work at being an attorney handling a state matter, especially with, pertaining to the counties. And it's a lot of work. And the reason I asked Mr. Davis is because a lot of you guys want to fight for your kids, grandparents, relatives, fathers, mothers. And I want to give you guys that opportunity to have an attorney to get your kids back. And I want you guys to take advantage of this opportunity, actually. I will be in the office. If you guys want to meet with me in the office and discuss your case or discuss the retainer, I'll be happy to have an appointment with you guys and meet you there. I should be in the office tomorrow, all day long, and Monday, and Tuesday, and Wednesday. So you guys let me know when you want to see me, meet with me, and we can discuss the retainer. Also, you can call the office at the 888 number that you see, 888-888-6582, and ask for Georgette, and they will take your name and phone number, and they will email me, and I will definitely give you a call back. So, thank you, Mr. Davis.
Certainly. I have a goal. I'm going to try to help 500 families in the next 30 days.
Yes.
So hopefully taking the price down, way down, more people enter and become part of our family at the law office.
Exactly. And also, that's my way of getting back at the social workers, seeing everybody have their kids back. And that's really the whole goal here. That is the goal, is to get your children back, because they are narcissistic, demonic entities who will not stop until they get what they want. Period. That's basically what social workers are. And that's in every county, every state. They're all trained the same exact way. And they don't like to lose, and they get what they want.
I wanted to know if you guys had any questions you wanted to ask me today. Sabrina, did you, or Georgette, did you have any questions? And if if you're watching this, also post your questions in the box under the comments section. We can all see them. And also, if you want to come on and join this live stream with us, post that as well. And our producer, Grace, will contact you and send you the link. And you can jump on this live stream with us. So, who has questions?
Oh, go ahead, Sabrina.
So something that I dealt with when I was dealing with my CPS case, and I keep hearing it over and over again on my show. The courts are telling people that they can't just go and hire an attorney, that they have to be specialized for that courtroom. Is that true?
Well, it's not true in California. And I don't think I've ever heard that before, but let me tell you this. In California, you have to be able to qualify to practice in a CPS courtroom. I think that's the only area of law where they require that. Now, if you don't have the qualifications and the experience, the judge can tell your client, either you waive appeal based upon the issue of ineffective assistance of counsel, or I'm not going to let your attorney practice in this courtroom. That's generally what happens. So sometimes, lawyers who have no experience in CPS matters end up representing a parent for whatever reason in that courtroom. And it's basically up to the discretion of the judge to allow you to practice. And if you do practice, generally your client has to sign a waiver that they won't argue ineffective assistance of counsel after everything is all over. Now, I've heard, this has happened a lot. I've heard this story a lot from people that I talk to. They will tell, social workers sometimes, allegedly, tell clients that you can't hire a private lawyer. That's absolutely false. You can hire a private lawyer. Some social workers tell clients, don't hire a private lawyer because we work better with the court-appointed attorneys. And generally, you can guess what that means. If it was me and they told me that, I'd run out and hire a private attorney right away. So I hope I answered your question, Sabrina.
Yes, thank you. I remember, being so confused. My mom was with 3 lawyers when I was growing up, and I always was helping them out, but never once did we do juvenile dependency. So that's why I thought that, okay, maybe it's correct. And the social worker told me, no, you can't hire your own attorney. They have to be specialized for this courtroom only. And I guarantee you don't know anyone that is specialized, blah, blah, blah. And I keep getting the same thing on my show with people telling me that they're being told the same thing.
Yeah. Well, I just told you what the law is. Sabrina, where was your case? What state?
California.
Yeah. So that's the law in California. In California, you can generally hire anyone you want. The judge has the right to inquire of their experience and knowledge. And if the judge doesn't think the person is qualified, the judge will excuse that attorney unless you, as the client, sign a waiver saying that you won't argue ineffective assistance, after you lose the case, presumably if you lost. So you can hire anyone you want. Now, a lot of times, they don't like to see private lawyers on the case. Private lawyers have a tendency to demand trials, to put on trials, that type of thing. So, there is kind of an unspoken, I don't know, rule sometimes among social workers and perhaps their own attorneys that they don't want private lawyers on the case. Funny thing, I have a trial coming up in another county, and they set it for, I think, 5 days of trial. And I didn't pick 5 days. It was a number of days were picked based upon discussions among attorneys and the judge. But we had a due date to turn in our witnesses, our witness list. And I think we turned in a witness list of like 20 or 22 people. And that caused a firestorm. And they want to have a special meeting about it and blah, blah, blah. But can you imagine? They're trying to take my client's children away from her permanently, and they're concerned that I have too many witnesses. It's not as if I don't know what I'm doing, right? I've probably done more cases than any of the attorneys on the case, been practicing in this area more years than anybody on the case. He's, radio show on KABC about juvenile dependency. I wrote a book about juvenile dependency. I have an ongoing YouTube channel with, I think, maybe about 400 videos. I know what I'm doing. It's just that they don't want to sit there and go through a long, drawn-out trial. Maybe 2 or 3 months ago, I did a case up in Northern California. I won't say the county. And it was a case where they were accusing my client of physically injuring a child, a baby, breaking bones and such. And when they saw my exhibit list, they went bonkers because I had so many, witnesses on the witness list. Now, don't forget, you're trying to take my child away from her permanently, and you're concerned that I have too many witnesses. Like, well, how do you figure that? Anyway, in that case, we called a number of our witnesses, and the court made a decision, and the decision was that the social worker did not prove her case, and she threw the case out. And my client's children had to be returned to her. So, evidence is important. People always talk about what does the law say? The law is important, but it's not as important as the evidence. Because generally judges and lawyers think they know the law, okay? And it's what's going to carry the day is the evidence you present in your favor. So if you go to trial, I tell people this right now, I see a lot of people going to trial. They have no witnesses, they have no evidence, no exhibits, and they think they're going to win, or they think they're going to have a chance to win. And I'm going to tell you 1 out of 1,000 is your chance on winning that type of case. Because when you go to court, the social worker always has evidence. She has the social worker report. For example, the jurisdiction disposition report, or the 6-month review report, or the 12-month review report. She always has evidence. And when lawyers argue without putting on witnesses, that's a recipe for a disaster for the parent. Because lawyer argument in California, probably in most states, I don't know, but in California, is not evidence. So it means nothing. You're trying to convince a judge to rule in your favor, and you haven't put forth one piece of evidence, not even the testimony of your own client. How are you going to win? You can't win. 999 times out of 1,000, you're going to lose. And I don't like those odds when you're talking about my children. So, let's quit focusing on the law so much. Oh, what does the law say? Doesn't the statute say this? Doesn't the rule say this? Let's focus on the evidence. How are you going to prove or disprove something with competent, admissible evidence? That's the key to these cases. And a lot of people don't focus on that. A lot of people don't even acknowledge that. I've been doing this so long. When I tell people this, they're like, I don't really believe you, Davis. Okay. I don't argue anymore with people. If that's what you want to believe, that's what you want to believe.
When, Mr. Davis, if a social worker's daughter is babysitting a kid on the weekend, isn't that a huge conflict of interest? A
You
foster
got to
kid.
you got to give me a little bit more
A
background fact.
Deidre, social worker, has her daughter babysit her kids on the weekend. Isn't that a huge conflict of interest?
Okay, who has custody of the kids? The parent?
No, the parent doesn't have custody of the kids.
Well, who has?
Social CPS does.
Okay, and who specifically?
The Deidre, social worker. Okay, she said now her kids is under her mom's care.
Okay.
But the social worker's child or teen, probably a teenager, is watching the kids on the weekend. Isn't that a conflict of interest? She's asking.
Okay, it depends on several factors, and this is actually a good question as an example for evidence. You can't say that just straight out it's a conflict of interest. You can't say that. And I'm going to tell you why. In order to determine something as a conflict of interest, you have to go through a 3 or 4 step analysis. All right? So although on the face you might think that's a conflict of interest, because you think that's just the law, it's not the answer to the question. You have to go through the analysis. And the analysis is you have to put forth evidence on each of those 3 or 4 factors. What if you found out that this babysitter wanted the children to be returned to the mother? What if you found that out? Would you consider it a conflict of interest?
But that's not the social worker's goal.
Okay, so like I said, everybody thinks they know what the law is. Everybody thinks they know what the answer is. It's not. You know, every legal question has an analysis that you have to go through. And that analysis means you have to apply the rule of law and the evidence to the fact situation to give you the answer. So when I tell you, hey, when you ask me, is that a conflict of interest? But the true answer is, it could be, but it could maybe not be. And I know you don't like that answer because everyone wants black and white answers, right? But the law is not black and white. And unfortunately, people don't want to accept that. The law is gray. Gray, gray, gray. Okay, so I would need to know a little bit more information. But just topically speaking, I would say, yeah, that could be a conflict of interest. Now, you got to prove it in court with legal analysis. So you see the important distinction? That could be a conflict of interest. That doesn't mean anything. Prove it in court by way of motion with and evidence and legal analysis to get the judge to say, oh, that's a conflict of interest. You know, if you reported that situation to the head of CPS in that county, or the head of CPS in that state, or even to the Department of Health and Human Services, who supervise all of the social workers in this country, they would even tell you, well, we have to go find out. Because, especially in the law, sometimes a spade doesn't look like a spade. So you can't just go up half-cocked and say, oh, that's a conflict of interest. And that, Sabrina, is what I was telling you. The evidence and the analysis is so important. It's so important. You know, the way a trial goes usually is generally people know the law in their minds. You got to show the evidence, the witnesses, the testimony, the exhibits, the documentary evidence, the pictures, the videos. And then at the end of the trial, the attorney is supposed to do something called a closing argument. in that closing argument, the attorney has to relate the law to the evidence that was shown. Try to convince the judge to believe your evidence so that the analysis goes in your favor. You know, this is a very difficult concept to wrap your head around. And I'll tell you, when I was a young lawyer, I had in my mind that certain procedures in juvenile court proceedings violated constitutional rights. I mean, I just firmly believed this, like maybe until I was a 7, 8 year lawyer. 7 or 8 year lawyer. And around year 10, a constitutional attorney explained to me why things that look unconstitutional on their face could end up being not unconstitutional. So that's just what I'm trying to tell you now. Let's not jump to a conclusion. You might be right, you might be wrong. But we're talking about your kids, so let's do the analysis. Let's get the evidence. I talked to someone recently and they said, oh, we know what we're just going to go to court. We know the judge is going to do the right thing. And I said, oh, okay. Now, I didn't say you're crazy. I didn't say that's a bad strategy. I didn't do any criticism whatsoever. I'm thinking that these people are going to be in for a huge surprise. Huge. They're going to call me back and they're going to say how corrupt the judge is. When in fact, the judge wasn't corrupt. The judge was applying law and rules and evidence that they knew nothing about. They just didn't know anything about it. So it's like going to play football and not knowing the rules. It's like getting on the tennis court and you don't know the rules.
Why is it?
If you go into court and you don't know the rules, 999 times out of 1,000, you're going to lose. Period. End of story. There was no corruption. Go ahead, Georgia. What were you going to ask?
In the WIC section 366.26, the first plan, the social worker is likely to recommend adoption by another person.
Time out.
Uh-huh.
Now, here is something that relates to just what I was talking about. You have to realize, first of all, that 366.26 applies to what I call Module 5 and Module 6. All right? It has nothing to do with Module 1, 2, 3, or 4. So when you tell me, let's talk about 366.26, you're telling me about a case that's in Module 5 or 6. Now, here's the important thing that a lot of people don't realize. If you're at 366.26, a lot of things have happened in the case. Certain court findings have already been made. Certain court orders have already been made. You can't go back to Module 1 and show how you were screwed and the allegations against you aren't true. That train has left the building. And unless you appeal and won the appeal, you better be focusing on 366.26. You better be focusing on Section 388, the petition to try to get more reunification services or have the children returned to you before your parental rights are terminated. You better be focused on a motion to ask for some type of bonding study. You better be focused on the age of the children, because a 12-year-old or older can stop a termination and an adoption. You need to be focused on those things. So if you ask me a question about 366.26, realize this train, this story, this case is several chapters old, and generally there's nothing you can do about it. But go ahead, I'm sorry for interrupting. Finish your question.
But can they prepare for a contested .26 hearing where the first hearing will be to inform the judge if they agree or disagree with the social worker's recommendations?
Yes.
Okay. And then if the recommendation is for adoption, do they immediately have to file for an appeal?
No.
No? Okay, what's next after that?
Okay. So I'm asking your questions literally. I have a feeling you might mean something else, but I don't know, because I'm not in your mind. Let me tell you what happens.
Okay.
Let me tell you what happens. After your rights
I
have
have
been...
no words. I can't. Go ahead.
You want me to answer the question? Okay. After your family reunification services have been terminated in California, and probably in most states, there's 120 days between that time and the time that you have the termination of your parental rights under 366.26. During that time, it's incumbent upon you to implement a strategy to try to reverse the finding of the termination of your family reunification services. Number one, you should always file a writ in California to challenge the termination of those services. Number two, you should continue with your case plan so that you and your attorney can file a 388 asking for more reunification services, more types of visitation, more custody of the child, that type of thing. We had a case not too long ago in the office where the mother's rights were, family reunification services were terminated. And by the time we got to the 2-6 hearing, 120 days, the judge returned the children to the mother. Now, how does that happen? We were going to the 2-6 hearing, and when the judge's plan or the social worker's plan was that the kids, the rights be terminated and they be adopted. Well, there's a lot of things you could do, but it's very case specific. I can't just tell you this is what you should do, because there's a plan A, there's a plan B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, and I need to know where you fall, and I can't tell you that unless perhaps I review your legal file, court file, and talk to you. It's just not simple. It's not waving a magic wand.
I just want you guys, you heard Mr. Davis, it's very complex. It is. Fighting them is very hard because their goal is they don't want to lose. They don't like to lose. Social workers do not like to lose. Oftentimes you guys tell me, hey, Ms. G, the court-appointed attorney is not, is telling you guys that your evidence doesn't matter. That is not true. Evidence does matter. It does matter. But he or she may not want to submit it into evidence. For some odd reason, they don't want to do it.
But it depends on what the evidence is.
That was my next question, actually, because we hear this a lot, that people try to bring evidence into court and they're not allowing them to submit it. How do they go about doing that when they have no choice but to be with the public defender and they're telling them they're not going to take their evidence?
Okay, Sabrina, so here's something that's very important. Sometimes people go to the .26 hearing with evidence that was relevant to Module 1 or Module 2. Okay, their overall innocence in the case. At a .26 hearing, that evidence is inadmissible.
What about before the .26 hearing? They've had the evidence all along.
Doesn't matter. It depends on what module you're at. That's what, you see, I said this, I think the last time we were on together. And I'm going to say this again, and I want you guys to really, really think about this, okay? What matters is what stage of the case you're at. All right? So let me give you the classic example. They're going to a .26 to have their parental rights terminated. They call me up and they tell me all of the reasons why the allegations of child abuse in the beginning were false. Now, based upon what I just told you, that would be inadmissible evidence at the 2-6 hearing. You have to focus on other issues. See, everyone thinks that the issue of whether they did the deed that justified the social worker taking the child away from them is always open, always in play on the table. And it's not. It's just not. Now, I'm sorry to tell you that, but I didn't write the laws. All I'm trying to do is figure out a way of getting your child back to you. And you're trying to tell me why the social worker was wrong, 12 months ago. And if I tell you, hey, Sabrina, it doesn't matter, your feelings are hurt. You think I don't care about the case, and you move on. But in actuality, Sabrina, what I'm telling you is how to win your case. You just don't realize it because you think something else is important. You think some other facts are important. If we say, well, the issue of whether I did the deed or not is true, isn't that always on the table? And the answer to that is, unfortunately, no. No, it's not. Now, as a non-lawyer, I would think that that's unfair and unreasonable. I would. Because if at any time I could prove that what you decided 12 months ago was false, I should be able to bring it up. That's the American way. Truth, justice, and the American way. But I can tell you from doing this for 35 plus years, that's not the law. It may be the law you want, but it ain't the law that exists. And these judges and social workers are operating on the law that exists now.
Oh,
So
that's BS.
if you want to, if you want to do and win, you need to focus on the statutes, on the case, and on the evidence for the hearing that's coming up. Ms. G thinks it's BS. But
no, I'm not saying what you're saying is BS. I'm talking about their BS. They're all BS because they, even though there's laws in place, they know how to go around it. They know how to set rules in their courts or in their entities to go around the law. So for all the social workers out there, you guys are scumbags. So let me tell you why. Because in the new law, when it comes to relative placement, Nancy Skinner law, the SB 325 law, it indicates clearly what's passed. This is a passing law that, sorry, let me correct myself, SB 354, Nancy Skinner, which removes obstacles in the foster care system that has prevented children from being placed with relative caregiver who may have past conviction. You social workers out there in LA County and Orange County and San Bernardino and Lancaster are telling relatives with past convictions that there is no such law. So you are not doing your job and you are trying to sabotage every chance a relative can get children placed with them for your own malicious reasons in your minds. So there is nobody out there that can tell me a social worker has integrity or character or any of the above combined together. Okay, so yes, I understand that Mr. Davis is an attorney, 35 years, he understands strategy and how to win cases. However, my thing is this. Parents oftentimes have evidence from the beginning of the case, from the beginning of the investigation phase of the case. We're talking about concrete evidence. For instance, a client or somebody who, or a potential client had a videotape at her son's playing in the park. And the child, she was happy videotaping her son, and then he fell from the slide. He injured his knee, and it's on the video. It's on the video. So the child goes to school, and then all of a sudden the teacher says, "Oh, there's a bruise on the child. Let's call CPS. Let's report it to the Child Protective Services." Without even talking to the mother, they immediately report it to Child Protective Services. They get involved. They come in, investigate, look at her place. Everything is great. She's a great mom. He's a great father. food in the refrigerator, et cetera, they have a home, their house is clean, all that. All of a sudden, the social worker leaves, comes back with a police officer removing the child with a court order. So the social workers are telling the judges there's abuse, and the judges automatically signs for it. And sometimes they go steal your children without a court order. So this crap with evidence, yes, they have evidence, but then the court-appointed attorney doesn't submit that evidence, that video of the mother recording the child because they were having fun day at the park, and the child injured himself, like every child does. I mean, every child. I injure myself, and I'm not a child. Okay, so it's kind of like automatically the first thing they do is call Child Protective Services. When I was growing up, and I would fall roller skating or running or whatever, and I injured my knee, or I have a bruise on my knee, my teachers never called Child Protective Services. So why all of a sudden Child Protective Services are called for every little thing, and the parents are not even questioned first? If that teacher would have called the parent and said, hey, Justin has a bruise on the knee, what happened? The mom could explain that to the teacher instead of calling Child Protective Services, because when you call them, they're like Pandora's box. You can't close Pandora's box once they're called. Their goal is to remove the children because of incentives that they get from the federal government. They make money. They're entities working through the state, and they make money for every child in their custody. And there is no checks and balances in the juvenile dependency system. The judges doesn't do checks and balances with them. Even if the judge ordered for the children to be returned to their mom, the social worker goes against it and starts harassing the parents and coming up with everything in their head to stop the reunification services that the judge actually ordered. And the judge doesn't, and then the court-appointed attorney is not speaking of that. And not one court-appointed attorney, I'm talking about LA County, Orange County, Riverside, San Bernardino, all of them, they don't address that issue. In fact, they're friends with the social workers. Oftentimes, the court-appointed attorneys know the social workers very well. And that is a conflict of interest. And another thing, why do court-appointed attorneys love to tell parents, admit that you did it, admit that you are guilty, and you will get your child back now? And it doesn't work. So the parents, from desperation, they admit they're guilty, even when they're not guilty, because in their mind, they think they're going to get their child back. Thus far from the truth. So my question is this, Mr. Davis. How can you make the court-appointed attorney work for you and not against you?
That's a very difficult question. Many years ago, maybe like 20 years ago, 25, maybe 30 years ago, I was a court-appointed attorney. And so I've seen this from both angles. And when I was a court-appointed attorney, at some point we represented parents, relatives, and children. So depending on the case, you could be representing a different person. But, it's hard to make someone do something that they don't want to do or they don't think is right. I can't say that I agree with you about the statements that you just made, because every case is so different. I've seen court-appointed attorneys do something against the client's, wishes that was beneficial to the client.
Mm-hmm.
Okay, and it could also be cases where court-appointed attorneys do something that isn't beneficial to the client. You just don't know. You don't know. And I can tell you that a lot of people that listen to these shows like yours, Miss G, or my show, they are unfortunately in that position where they're unhappy with the results and the outcome. There are many more people that don't say anything. So we don't know if they're happy with the results or unhappy with the results. We just don't know. We have a very small population of people that call us, and they're generally people that are not happy with the services they're getting, and they want to change. Sometimes people call me and they want to change because they're not happy with their private attorney. You know, so it just depends. Sabrina, did you have another question for me?
Yes. Is there a statute of limitation on how long, like, you can go after CPS?
Yes, there is. And I'm going to assume you mean under, well, I think it's the same under state and federal in California. It's 2 years.
2 years. Okay.
Now, here's the question you want to know. You should be asking me. 2 years from what date?
Okay.
Right?
Yeah.
Because 2 years from the case starting to 2 years from you getting the kids back, those are different dates.
Mhm.
So it depends. You have to go through some type of analysis, what I was mentioning earlier. It's never the same for every kind of case.
What about for children who have gone through it and feel that they were wronged by CPS? Do they have a chance to take action when they are older or of age?
They have 2 years from the time they turn 18, generally speaking. Now, there are new statutes on the books in the last few years that address kids that have been sexually abused, especially those kids that have been sexually abused in foster homes, right?
Right.
So they have a lot longer time, but there is a legal analysis for that to determine when the time started ticking, when the times ends, that type of thing. So it's just not, let me check the chart. That's not how it works in a lot of cases. But children generally have a longer time than the parent.
Okay, good to know. Thank you.
Did you have another question?
If we can go back to the evidence deal, how would you go about submitting the evidence into court, and what is considered legit evidence, like that the courts will actually hear? I have a lot of people telling me that they're unable to submit anything for the judge or their court, and I tell them to go to the clerk's office and file it or whatever, and they're telling me no, they reject it on all levels. How do you go about doing that?
Okay, I'm going to answer that. That's a great question, by the way. And before I answer that question, Grace, executive producer Grace, there's a woman named Angela Law that wanted to get on the show with us. I don't know if you've been able to contact her. We'll try to contact her because, not Angel Law wanted to jump on with us. Okay, Sabrina, back to your question. This is what I would do. I was thinking about this the other day. I'm doing a video series on training lawyers and training parents on how to do juvenile dependency cases. And the best way I think that you can do it is, take a look at the petition, the 300 petition that contains the allegations against you. And generally, they're divided up into different, what they call counts, an A1, an A2, an A3, a B1, a B2, a B3, C1, C2, C3, and so on, okay? And you should put that on a chart by count. Then, each count has about 5 or 6 sentences sometimes in the count. Then you should break those sentences out, okay? And then you should decide what evidence they're using against you to prove that sentence to be true. And then you should decide the people that can testify, the documents that can be shown, or the pictures or videos that can be shown to contradict that statement. And you should do that all the way through. Now, imagine that takes a lot of time, a lot of effort, a lot of work. Right? So That's the best way to do it. And then to determine after you get the people on the list and the evidence and the documents and pictures, then you should talk to your attorney to determine, how is this going to be admissible? I used to give an example of a guy who went to court and he had all the medical evidence in the records to show or to basically win his case. Okay? And when he went to court and he represented himself, the judge wouldn't listen or wouldn't examine those documents. He came to me and he said, Davis, that judge was correct. And I had to tell him something. I said, I don't think the judge was correct. I don't think you knew California evidence. You didn't do the right things to get those medical records into evidence. He says, but I got the records. They're all true. And, I didn't want to argue with him. I said, suffice it to say that you did not do what is necessary. Well, what's necessary? Well, I said, look, I don't have time to give you a 3-hour lesson on the business record exceptions to the hearsay rule in California, right? This is, a 1-hour consultation, free at that. I said, if you want to go back to court and do it the right way, I can help you do that. So every particular type of evidence has its own special rules. And that's what you have to address. It's just not, hey, this seems fair in my heart. The judge should look at it. You got to break it down. Is there a hearsay exception? Is there a subpoena, custodian of records? On and on and on. So what people think sometimes, they got great evidence, but it's not admissible. And that's not somebody being corrupt. That's you not knowing the rules. Does that make sense?
Yeah, absolutely. And what happens if your public defender won't accept your evidence, even though it is like legitimate evidence? How would you go about submitting the documents to the courts?
Well, in my experience, a lot of judges wouldn't let you do that because your case has to go through your attorney. And some judges might do it, but in general, I got the feeling that, or have noticed that doesn't work because they are trying to protect your rights in your record, right? You can't have 2 lawyers talking on one case because you might be saying ABC, your lawyer's saying XYZ, and who better knows the evidence and the rules? You or the lawyer, right?
Yeah.
So if the lawyer says, I'm not going to do it, you should immediately file what's called, in California anyway, a request for a new court-appointed attorney. And in California, they call it a Marsden hearing, M-A-R-S-D-E-N. A Marsden motion. Now, like everything else in the law, there's probably a 4-part test. You have to present competent evidence on each of those elements for the judge to give you a new court-appointed attorney. A lot of people go into a Marsden motion, they don't have their thoughts or their evidence or their argument prioritized, organized, and then they're pissed off that the judge won't give them a new attorney. And the real reason why the judge won't give them a new attorney is because they didn't follow the law. Well, how are they supposed to know what the law is? They're just individuals. That's the one thing, and I think I've told you this, Georgette, before. In law school, one of the first year classes, a teacher told us, a professor told us this, and I found it very hard to accept, especially from where I was from. And that was, ignorance of the law is no excuse. I didn't make that rule, right? But that's just the law. So if you go into a Marsden hearing and you do it the wrong way, shame on you.
Mr. Davis, my passion in life until the day I die until I take my last breath is to make sure every mother and father and grandparents have kids back. And that's my passion. And a lot of you guys that watch my show know me personally. When I am passionate about what I do, is to make sure you guys get your kids back. In fact, I had a conversation with several attorneys in our office, and they love the idea of, Mr. Davis. When I spoke to Mr. Davis about the 50% off, they loved it because they also are passionate about getting your kids home to you. And that's what's really important. And I just want to make you guys understand that your court-appointed attorney, I understand Mr. Davis has his own view about them. I have my own personal view about them. Everybody's entitled to their own opinion. However, court-appointed attorneys are scumbags, and that's my opinion. I'm not saying that's coming from Attorney Davis. That's my opinion. And they don't really fight for people's rights. They're free to you, but they get paid from the county. They're county employees. So I need you guys to understand that when you are dealing with an investigative phase of, the part, don't think that what they tell you is actually the truth. Because oftentimes you guys call me back and say, Miss G, I wish I hired an attorney other than dealing with my court-appointed attorney. Because the social worker said this to me, but then something else happened. And then your attorney, your court-appointed attorney tells you, hey, don't worry, this is what's going to happen this day. This is what's going to happen this day. And a completely opposite happens. And then you end up going to your 0.26 hearing and termination of your parental rights and termination of your unification services. And they don't, they move so quick. And I tell you guys this, they're 20 steps ahead of you. In fact, it's not even 20 steps ahead of you anymore. It's 30 steps ahead of you. They know exactly what they're going to do before the initial communication with you. So I'm telling you right now, do not speak to a social worker. When they contact you, you immediately contact a juvenile dependency attorney. Do not contact a criminal attorney. Do not contact an immigration attorney. Like this one caller hired an immigration attorney to help her with her CPS case. He cannot help you with your CPS case. He doesn't understand jurisdiction. He doesn't understand the laws when it comes to juvenile dependency matters. Mr. Davis and his team has been doing this for years. So criminal attorneys can help you. Immigration attorneys can help you. Family law attorneys can help you. We have a case where it was a family law case and somehow it transitioned into a juvenile dependency case because of the allegations of the father against the mom to CPS. So they sided with him, as they usually do side with the abuser. So therefore, that family law attorney never handled a juvenile dependency case, but she kept her on the case. Then she went to court, and the judge kicked that attorney out of court. Literally kicked her out of court. Told her to get out. So she called me back and she said, how dare the judge kick her out? I said, because she has no idea anything about CPS or what CPS or laws or anything like that. So therefore, be careful. Do not trust everything you hear. You need to understand the law. And some of you guys say you Googled. Don't Google. My doctor even told me that because I diagnosed myself before I go see him, and before I go see him, I'm half dead. And he actually told me today when I was getting my knee injection, he said, stop Googling your medical condition because you're going to give yourself a stroke, literally. So I started thinking to myself, I said, well, same thing goes with law. Same thing goes with, legal questions. You have to be careful who you're asking, and you have to be careful who's answering those questions. And Mr. Davis has, two links. the free CPS report link.com, and also the Sue CPS info link. I'll be happy to text it to you guys. I've been texting you guys his book as well, which breaks down everything to you. All the hearings you guys go to. This book has been my Bible. Like literally, I write notes. You know, I ask him questions and I write notes. This book is, I highlight pages. It's been my Bible, literally. I'm telling you guys, do not just take somebody else's word. Mr. Davis makes it accessible for you guys. And I also have it in a link where I can just send it to you guys. And it will be on your phone and you can look at it. And it's a free link. You don't have to pay for anything. And take advantage of what Mr. Davis is making available for you guys. Because he's been doing this for so many years. Yes, I do argue with him sometimes because I want him to give me what I want to hear. I want him to say what I want to hear. But I know he's right. A part of me argues with him, but I know he's right. And yes,
wait,
Mr.
hold
Davis,
on. Stop. Grace, cut that part of the video and we're going to post that everywhere. This is national news.
Mr. Davis is right. And oftentimes I tell you guys, I would argue with him and then I sit back and I lay back and I'm like, he was right. Why did I argue with him? And I don't know why I do that, but I do it sometimes. I don't know why. But he knows his stuff. He really, really does. And you guys really need to understand that the juvenile system is so corrupt and so out of control. And again, I mentioned to you guys before the doctor in Beverly Hills. She was settled. They settled for $150,000. And she's going after them for $750 million. And because they stole her daughters and placed them with the abuser father. And she had nothing against her for them to do that. They didn't even have a warrant to steal her daughters. So you can sue a social worker, but do not expect a social worker to lose her job because you sued them. In fact, they don't lose their job. Oftentimes they get promoted. Am I right, Mr. Davis?
Yes.
Really? Did you just say yes?
I did say yes.
I don't hear that often. I'm sorry. I need to hear it again. Wow. He agreed with me in one thing. Wow. That's great. Okay, so Kayla said, I wish I had my son. I haven't seen him in over 2 years. My rights got terminated. What county was your case in, Kayla? Also, Deidre said, but when CPS comes and steal your children wrongfully and then use parents are left to fight this whole thing and do not know a thing about dependency cases or case until it's too late and risk losing your break. Maria also said, the social worker lied to me. I lost my son because I thought I could trust her. Exactly. Let's focus on that for a second, Maria. I tell people this all the time. People call me and say, Miss G, the social worker is my friend. She's not your friend. He's not your buddy. They're after one thing. Money. That's it. Money. If you go to a car salesman to buy a car or looking at a car, he or she will do everything possible to sell you that car. Because after they sell you that car, there's a commission behind it. And then I got a text message when I was doing the show, and I don't know if you guys kind of noticed, I've been looking at my phone. And she said to me, she said, Miss G, I wanted to do a consultation with Mr. Davis. I told her how much the consultation is. She said, but I spend it on a consultation for my hair. I'm not going to mention who that person is, obviously, but again, what's more important, your hair or a consultation with an attorney that can actually consult you on your case? That's very important question to ask yourself. I would be bald I wouldn't care. Me personally. But you guys have to think to yourself what's more important. Even a hairdresser charges for a consultation. I didn't know that, guys. I had no idea. But a hairdresser charges for a consultation.
I'm a hairdresser. I don't charge for consults.
But hairdressers do charge for consultations.
Yeah.
I had no idea until he texted me this. So what I'm trying to tell you guys, you have to see what's more important. Buying a new car, a hair consultation, or getting your kids back. We have a client, I would never forget him. He said, Miss G, I lived with my brother and my sister-in-law until I got my kids back to hire an attorney. He got his kids back. Now he has 2 businesses on Amazon, and he has his own place now. Not a renter. He owns his own house now. But he lost everything to gain the most important thing to him, which are his kids. And I will never forget him. And in fact, a couple of times he would text me just to see how I'm doing. So you guys need to look at the important thing in life is to get your kids back, because there's no money. And I swear to God, when I tell you this woman that's suing the department for $750 million, no money can ever justify what they put her through or what they put the kids through. It should be billions of dollars, not millions of dollars. And even that is not enough. So you guys need to be very mindful. And also the groups that you guys are following on Facebook pages, most of them are social workers. They ask you where the case is. They ask you who's your social worker. They ask you what county your case in, and they contact that social worker to notify her or him that you are talking about your case. So if the social worker comes to you and tells you can't talk about a case on social media, you better believe that you already spoke to somebody else about that case on social media who say they're child advocate or children advocate. You have to be mindful and discern who you are speaking to or with. Again, they're not attorneys. If somebody says, oh, after you watch my show, write a good review about my show, and then I'm going to give you a certificate so you can give it to your attorney to tell your attorney that you were on this show and you've done everything in your power, to get your children back. What the hell does that mean? I've heard that from 4 different people. I'm not going to say the name of the show or the person, but Mr. Davis hopefully knows who I'm talking about. But there's people that even tell Mr. Davis, hey, this person said that she's a sitting attorney. She's not a sitting attorney. And all the advice she's giving people is actually from Davis's show or Mr. Davis. So you guys need to be very mindful. A piece of paper is not going to change the judge's mind. That's ridiculous. And anybody that tells you to donate to their show because of their help for you and you donate to them, that's ridiculous too. Because you're paying a non-sitting attorney that has no idea about CPS laws. They only have an idea of what they hear from a professional. So you guys need to be very careful with that.
Hey, ladies, I see we're at our stopping point. Are there any last questions you'd like to ask me for this afternoon?
Yes, Mr. Davis. If I may ask, and hopefully you will agree, can we, yes, wait, let me finish. Please wait. If I may please extend the 50% until Wednesday or Thursday.
Georgia.
Wednesday. Wednesday. Okay, until Wednesday. Please, until Wednesday. Don't embarrass me on live.
Sabrina, what do you think?
I think yes, because not everybody has the kind of money just laying around. You know, for me, example, I'd have to go beg my in-laws, and they're older, and it takes them a while to do it. You know, so yeah, I agree with Georgette.
Thank you, Sabrina. God bless you. Please, Mr. Davis.
Okay, Georgette, Wednesday.
Wednesday it is. Thank you,
Wednesday,
Mr. Davis.
Wednesday, 12 noon.
I was hoping 4 o'clock, but I'm not gonna push it. 12 noon is fine. 12 noon is fine. Thank you, Mr. Davis. Have a nice
All
weekend.
right.
Okay.
Thank you, ladies. I'll see you guys later.
Thank you
Bye,
so
Sabrina. Love
Bye,
you.
Dad, I love you. Thank you so much, Mr. Davis.
All righty.
Bye.
Bye-bye.
Sweetheart.
Bye.